Good. Yes, sir. Good evening to all of you. Today we discuss about some other planes which have to be understood. Today we'll discuss about declaration of legal heirs as far as personal legal heirs or what is called as far as property is concerned. There are two separate suits. First, as far as once the disease dies, then the problem starts. Then the wife and the children want to be recognized as legal heirs of the deceased because the deceased must have left behind some rights. Actually, for all practical purposes, the legal heirs of the deceased will have to come on record. Then, in that case, the proper course is to file a suit for declaration. Please remember, if you don't write the word legal heirs, you'll have to say legal status. Yes, if you write legal heirs, your suit will be dismissed. That is the judgment of the Supreme Court also. Here, normally, the widow, the person who dies, he leaves behind his widow and sons and daughters. They are his legal heirs. So their status has to be recognized by the court. So for that purpose, please remember in the as far as the debts are concerned or money is concerned, if deposits are there or savings bank account is there or some investment is there, as far as that is concerned, you will have to file an OP under 370 to 372 of the Indian Succession Act. That is as far as mobile property is concerned or money is concerned. But here, as far as immobile property is concerned, succession certificate does not cover this particular aspect. This is a basic thing you must remember, sir. Most of the people, when they correspond, the authorities write to them saying that please obtain a succession certificate. Please remember, as far as immobile property is concerned, no succession certificate is issued. But one more thing you must remember, sir, is suppose you are a government servant, the person who is deceased was a government servant, the MRO was authorized to give what is called family member certificate. But even then, I was told now they are also discontinuing it. The government is also not recognizing it. But the proper course would be that suppose you want to be recognized as the sons and widow and children of the deceased, you must file a suit called declaration. The first thing is in the court of the junior civil judge, city civil court, Secunderabad. I'm talking from Hyderabad's point of view. Suppose it is in the district, you call it as junior civil judge Rangareddy district or junior civil judge Siddipet, like that. Then OS number, all suits for declaration are numbered as suits on the original side and it is called OS number of whichever year it may be. Then between whoever are the legal heirs, or they want to be recognized for the legal status, they should be made as what is called plaintiffs. And normal understanding is you mention it as all concerned. Please remember, as per the provisions of section 34 and 35 of the specific relief act, a status, position, character, or cadre should be asserted and should be denied by the opposite side, and then only a suit for declaration is maintainable. That is the reason we make a formal party called the GHMC, circle number 18 or whatever it is, behind courthouse compound, Secunderabad. Why? Because you make a semblance of any fight and say they are made as defendants. Then you say suit for declaration of legal status or the petitioners. Then same thing, the plaintiffs, I'm sorry. The plaintiffs above named beg to state as follows. First, second paragraph is name, address, and description of the plaintiffs. Second paragraph is name, address, and description of the defendants. Third one is the address for service of all processes and notices on the plaintiffs is that of their counsel. What suppose you are appearing, your name, your phone number, cell number, and your email number, and whatever address you have got, you please mention it. The next paragraph is the address for service of all summons and notices on the defendants is the same as given above in the cause title. I also define what a cause title means. Cause title means the description of the parties as shown above. That is what is called name of the petitioners, then defendants rather. You say same, you need not repeat it again. Then we come to the next paragraph. So you are saying that brief facts of the case. A, the so and so, that is Mr. The plaintiffs respectfully submit that originally Mr. So and so was the is the father, is the husband and father of the plaintiff's above name. Full stop. That the deceased so and so expired on so and so date, leaving behind the plaintiffs as his sole legal heirs who have succeeded to his rights as per the Hindu Succession Act. That's first paragraph. Second paragraph should be the death certificate of the deceased is filed herewith and marked as document number one. Full stop. That subsequent to the death of the deceased, the plaintiffs approach the defendant number two to recognize their rights and include their names in their registers. But the defendant number two refused to do so, stating that the plaintiff should obtain a declaration from a civil court as regards their status, and hence the plaintiffs have no other alternative than to file the present suit for declaration that they are entitled to their legal status as the legal heirs of the deceased Mr. So and so. Then, in this regard, the plaintiffs have also addressed a legal notice to the defendant number two to recognize their rights, but the defendant number two directed the plaintiffs to file a suit and obtain a declaration from a competent civil court, and hence the plaintiff have no other alternative than to file the present suit. The office copy of the notice, together with the reply issued by the defendant number two, are filed and marked as document number so and so and so and so. Next paragraph is cause of action for the suit arose on dash when the deceased so and so expired, leaving behind the plaintiffs as his legal heirs, and also on so and so date when the plaintiffs called upon the defendant number two to recognize their legal status as the heirs of the deceased Mr. So and so. Next para is this honorable court has jurisdiction to try this suit as the parties reside as the deceased and the parties reside at house number so and so, situated at Regimental Bazaar, Secunderabad, within the jurisdiction of this court. Next paragraph is the suit is valued for the purposes of court fee and jurisdiction at 10,000 or 20,000. Please, previously they used to accept 10,000. Now below 20,000 they are not accepting it, but you have to value it at 30,000. That is the notional value now. The suit is valued for the purpose of court fee and jurisdiction at 30,000, and a court fee of rupees dash is paid under section 24D of the TGCSV Act. That means 24D. Why do I say that? Is there is no provision provided for payment of court fee. That is, whenever no provision is mentioned, 24D applies. You can value it at your own figure. Then next paragraph is the uh, the plaintiffs further submit that they approach the defendant number two to recognize their status as legal heirs as the heirs of the deceased, but since the defendant number two denied the same and refused to do so, the plaintiffs have no other alternative than to file the present suit. Next paragraph will be the plaintiffs further submit that they have not filed any suit in respect of the same cause of action in any court, nor any suit is pending. Last paragraph will be the prayer clause. This has to be very carefully worded, sir. The plaintiffs therefore pray for a judgment and decree for declaration to declare them as entitled to the legal status as widow and children of the deceased Mr. So and so. Then last one is for cost of the suit, and then verification, like signature and verification. Wherever it is verified, the counsel also signs. Then after that, whatever documents you are filing, you mention it as 1, 2, 3, 4, 5, 6 as list of documents filed along with the plaint, and then you need not mention the schedule, please, because we are only asking for legal status. This is one type of suit. The other type of suit which can visualize as far as legal status is concerned. Suppose the deceased has left behind any property and the widow wants to be included, her name to be mutated in the municipal records as the legal heir of the deceased. What is required is the same averments should be mentioned, but one paragraph you should say that the deceased left behind a property bearing house number so and so, admission so and so, situated at so and so at the time of his death. And after this death, the plaintiffs have succeeded to his rights by virtue of being entitled to the legal status as the successors of the deceased. Then you also mentioned the same thing that immediately after the death of the deceased, the plaintiffs approached the defendant number two to mutate their names in the concerned records, but the defendant number two directed the plaintiffs to approach a civil court and obtain succession, and hence the plaintiffs have no other alternative than to file the present suit to declare their status as the widow and children of the deceased. Then next paragraph is suit is valued. Here is important, sir, because there is a judgment of our High Court rendered by Justice L. Narasimha Reddy regarding this particular position. Please remember, a widow who should not lose anything in her life, she loses her husband. The children who should have the affection of their father, they lose their father. But please remember, law is so harsh. In this particular judgment, Justice L. Narasimha Reddy laid down, saying, sir, as far as the suit for declaration in respect of property is concerned, the court fee has to be paid on half the market value of the property under same 24D of the TSCV Act. Please remember, this is very, very harsh. And in one of the seminars, I asked this particular judge, was happened to me, my student at the law college, sir, is it not a harsh judgment? He said, I myself know it's a wrong judgment, but it has not been challenged in the Supreme Court, and still that judgment remains. So, a widow who should not lose anything in her life, the children who are deprived of the affection of their father, they are asked to pay half the market value of the property in order to get a declaration. But that is the present factual situation, sir. Then next paragraph is no suit is filed. Last paragraph will be the plaintiffs therefore pray for a judgment and decree to declare the plaintiffs as the legal entitled to the legal status as successors of the deceased in respect of house number so and so, administering so and so, situated at so and for costs of the suit. Then other things follow. Then in the schedule you have to mention, because it is concerning immobile property, the schedule of the property has to be clearly given. And one more important thing you must remember is, whenever you ask for declaration of legal status as far as immobile property is concerned, you have to obtain the valuation certificate from the concerned sub-registrar, because the court fee has to be computed on the market value of the property, half the market value. So valuation certificate is absolutely essential. Then, one more thing you must remember is that whenever you want to maintain a suit for declaration, you will have to assert your status, you will have to assert your position, you have to assert your character, you will have to assert your cadre, and it should be denied by the opposite side. Then only a suit for declaration is maintainable. So, that is the reason, whether you like it or not, you will have to mention that paragraph. Then, what are the papers you filed, sir? You filed the BATA, that is process form, Form 61 of the Civil Rules of Practice, fill it up. Then also you file what is called summons for settlement of issues under Order 5. And for each party, you have to submit it in triplicate. And then after that, you also file what is called Form number 8. That is what is called valuation of the property. There's a printed form for that. You fill it up and file. And then along with the plain, you also file what is called verification affidavit under Order 6, Rule 15, bracket 4, CPC. And then along with that also you file what is called an affidavit under Order 6, Rule 14, CPC, in the form of an affidavit stating all the facts, and also saying the names, addresses, and description of the plaintiff, names, addresses, and description of the defendant, and then defendants, and then the deponent signs, sworn and signed, so on and so forth. Then along with that, of course, you know that Wakalatnama also has to be filed by your advocate, whoever is appearing for you. And please remember, the list of documents on which you rely, that is most important, is the death certificate of the deceased, and then your Aadhaar cards to show your relationship with the deceased. Then third one is the property documents, if possible, certified copy of that document through which your previous predecessor in title acquired title. And then you file the valuation certificate or the legal notice and the reply, if any, given. And along with that, the valuation certificate also is to be filed, and provide extra copies of the plaint and other papers to the opposite side whenever they appear. And one more important thing you must remember is under Order 6, Rule 1, all plaints will have to be filed in duplicate. And next one is you will also have to provide one extra copy for the purpose of scanning, that is for computer. And unless you do all those things, your suit will not be numbered. But one more harsh thing as far as immovable property is concerned, half the market value has to be paid towards, it should be valued at half the market value, and court fee should be paid. As far as the first one which I discussed, no need of valuing it at half the market value. Straight away you can give any value you like. That is normally now the trend has changed. You will have to value it at 30,000 and pay the court fee accordingly. And there you need not pay on half the market value. But valuation certificate is required when you ask for declaration regarding immovable property. Unfortunately, the Indian Succession Act is absent on this particular aspect as far as immovable property is concerned. Perhaps it would have been good enough if if the Indian Succession Act also mentioned about immovable properties. That would have helped us to say that wild judgments need not be given on this particular point. So these are the two suits, the two plaints which you filed in respect of legal status. Don't use the word legal heirs. If you use the word legal heirs, your suit will be dismissed. Court cannot go into that aspect. Court can only declare your legal status as a widow or children of the deceased, so and so. These are the two planes which I think along with this now we have completed 7 planes. Now the next one we'll go is, I think I've also discussed the Transfer of Property Act eviction suits I think yesterday. Vedama. Just please excuse me. So next type of suit which you ఏమండి మీరు 30th పెట్టుకొని ఇవాళ ఇస్తే ఎట్లా? Sir, you said 3 weeks. Yeah, 3 weeks time is required for counter and next type of suit which we discuss is suits for redemption. Suits for redemption is, this is a type of right which is available to a mortgagor. That is redemption. The word redemption comes from the word redeem. Redeem is take back all the securities, take back all the documents which are given at the time of awaiting the loan. And this is a right which is available to a mortgagor to get back his securities duly redeemed. And that such type of suit is what is called suit for redemption. So this type of suit is filed by a mortgagor. And please remember, as far as a redemption of mortgage is concerned, the period for redemption is 30 years from the date when the amount becomes due. And the mortgagor need not wait till the mortgagee files a suit for enforcing the mortgage. He can file the suit within a period of 30 years, provided his right of getting back the property, redeeming the property, is not extinguished by a decree passed by a court. With this background, we go into the pleading. Whichever court you want to write, in the court of so and so, a plaint under section, a plaint under Order 34 CPC, because mortgage suits are always filed under Order 34. Then you say in the court of so and so. Then you say OS number of 2024. Then you give the names and addresses of the parties as plaintiffs and defendants, and then beneath it you mention it as suit for redemption of mortgage dated so and so. Then you say the plaintiff above name begs to state as follows: 1. Name, address, and description of the plaintiffs. Name, address, and description of the defendant. Third one is the address for service of all summons and notices on the plaintiff is that of his counsel so and so, with the email number and the cell number. And then the address wherever the advocate is carrying on his office. Then next one, the address for service of all summons and notices on the defendants is the same as given above in the cause title. Then the next paragraph should be brief facts of the case. A, that the plaintiff approached the defendant for working capital arrangements and the CC working capital on so and so date, and executed an agreement for working capital in favor of the defendant on so and so date, and the original agreement, or the copy of the agreement is filed and marked as document number one, and the loan facilities granted to the plaintiffs was secured by equitable mortgage of the property documents of the property documents of the plaintiffs, namely so and so, and the copy of the said deposit is filed and marked as document number two. Next para. As per the terms of the loan, the loan has to be repaid within 60 months or 80 months, and the EMIs was being paid, and still a sum of rupees so and so is due and payable towards the loan facilities, and subsequently the plaintiff approached the defendant to release the documents and also promised to pay back the entire amount due towards the principal, interest and cost, but the defendant refused to permit the plaintiff to take back the documents through redemption, and hence the plaintiff has no other alternative than to file the present suit. Next para. That the plaintiff, through his legal notice dated so and so, addressed to the defendant, called upon the defendant to receive whatever amounts are due and payable towards the loan facilities and also release the documents. The defendant received the notice but sent a reply stating that they cannot release the documents. And since the defendant has not handed over, the defendant has not permitted the plaintiff to redeem the documents, he is constrained to file the present suit. Then next para will be cause of action for the present suit arose on so and so date when the plaintiff availed the loan facilities from the defendant and executed documents in the form of promissory note and agreement, so on and so forth, and even the collateral security by way of equitable mortgage of his property, and on subsequent dates when the plaintiff through his legal notice expressed his intention to pay back the loan amount, but the defendant gave a reply, not reply avoiding handing over the documents. And hence, the plaintiff has no other alternative than to file the present suit. Next para is this honorable court has got jurisdiction to try this suit as the suit scheduled property is located at Pedambarpet within the jurisdiction of the Rangareddy courts, and hence maintainable under the law. Next one is the suit is valued for the purpose of court fee and jurisdiction at whatever amount is due towards the loan, and that is you say at rupees so and so, and a court fee of rupees dash is paid under section 20, read with schedule 1, article 1b and c TSCV Act. Next para should be the plaintiff further declares that he has not filed any suit in respect of the same cause of action, nor any suit is pending. Next para should be the suit is within time and within the period of limitation, as the suit is filed within 30 years and maintainable under section 61 and 62, article 61 and 62 of the Limitation Act. And the last paragraph should be the plaintiff therefore prays for a judgment and decree a decree for redemption of the mortgage dated so and so, availed by the plaintiff from the defendant, and together with the return of all the securities taken from the plaintiff at the time of disbursement of the loan. And B1 is that is to say cost of the suit, and then plaintiff signs, the counsel signs on the other side, and the verification and the place of verification is mentioned, and then down you mention the plaintiff also signs, and then after that you mention the list of documents which are filed along with the plaint 1, 2, 3, 4, 5, 6, and then the plaintiff signs. Then the schedule of property also you mention along with the boundaries, and then down one you mention as the plaintiff declared that the schedule mentioned above is true and correct, and then he signs, and then the counsel also signs, and the docket is prepared and is normally filed in duplicate along with a verification affidavit under Order 6, Rule 15, bracket 4, and along with that, an affidavit under Order 6, Rule 14, CPC, mentioning the names of the plaintiffs and their address, mentioning the name of the defendant and their address, and say that the addresses mentioned above of the parties are true and correct, and then the deponent signs and it's sworn and signed. And along with that, you also file what is called the BATA or process under Form 60, that is Form 61, process form as you call it. And then along with that, as many defendants are there, you supply three summons form in summons for settlement of issues under Order 5, because you have to pay a court fee through court as well as by registered post, and enclose the copy of the plain, and whatever then next one is whatever documents are filed, you file it under form number 51 of the civil rules of practice, and then you mention each document, and then supply extra copy of the documents to the opposite side. So this is how a suit for redemption is filed. But one more thing you must remember: the classic rule of law of mortgages is the liability, the enforcement, the as far as the right of redemption and right of foreclosure, which is exercised by the mortgagor and mortgagee, are coextensive. Coextensive is they exist together. One does not live without the other. Something like they're like an ideal couple, husband and wife. But the question is, the mortgagor need not wait till the mortgagee brings a suit, or mortgagee need not wait till the mortgagor brings a suit. So the question is, at any time when the money becomes due, the mortgagee can enforce the mortgage. As far as the mortgagor is concerned, if the mortgagee has not filed a suit and is interested to get back his property, he can file a suit for redemption. One need not wait for the other. That is the reason foreclosure and redemption are coextensive with each other. And the provision of Limitation Act, which applies to all these type of suits, are Article 61 and 62 of the Limitation Act. As far as mortgagor is concerned, it is 30 years. But as far as the mortgage is concerned, it is 12 years from the date when the mortgage money becomes due. So this is as far as suit for redemption is concerned. Then next one is different kinds of mortgages, how the suits are prepared. To understand that, I think I defined each kind of mortgage also. Let us go from the beginning. That is, mortgage. How is a mortgage defined, sir? Mortgage is defined under Section 58 of the Transfer of Property Act. Again, I repeat, interest created in respect of specific immobile property, interest created in respect of specific immobile property for the purpose of securing a loan paid, promise, part paid, or part promise. It is called a transaction of mortgage, and the person who offers the property as security is called the mortgagor, and the person to whom the property is offered as security is called the mortgage, and the transaction itself is called a mortgage. So here we have discussed about what is called a suit for redemption. Now we'll discuss a suit for foreclosure. Who exercises this right, sir? This right is exercised by the mortgagee or by the creditor. That is called a suit for foreclosure or sale, whatever it may be. If you take the case of, let us go one mortgage after another. In the case of simple mortgage, how a simple mortgage is defined under 58A, it means where there's a personal liability on the part of the mortgagor to pay the money. There's a personal liability. And in the default of payment, there's a charge is imposed on some property which becomes answerable for payment of the loan to the creditor or to the mortgagee. First one is personal liability. Second one is a charge is created on a specific immobile property which is provided as security to the mortgagee. So it is twofold. You can take a personal decree. You can also take a decree for mortgage. So whenever a suit is filed under a simple mortgage, what should be the averments? I will not go through the other averments, please. I will only go through para 5. That is the brief facts of the case. A, that on so and so date, the plaintiff, who is the debtor or the mortgagor, availed loan facilities. I'm sorry. This is a suit filed by the mortgagee, sir. I'm sorry, very very sorry. The plaintiff, who is the creditor, and the mortgagee advanced loan facilities to the defendant under the whatever facility it is there on so and so date, and the defendant executed a promissory note and receipt in proof of having, and also the agreement in proof of having availed the loan. As per the terms and conditions of the loan, the loan has to be discharged within a period of 60 months or 75 months as per the terms. And the uh, next full stop. The original promissory note and receipt, along with the documents executed by the executed by the defendant, are filed and marked as document number 1 to 3. Next para. That the plaintiff, that the defendant, that on so and so date, the defendant also created a charge in respect of his property bearing number so and made it very clear that in the event of his failure to pay the mortgage debt, the mortgagee shall be that the plaintiff shall be entitled to proceed against that property by enforcement of the charge, selling that property, and then recovering his dues. And the property documents regarding the charge created is filed and marked so and so, and the charge agreement through which the charge was created is also filed and marked as document number so and so. Next paragraph. The question is, since the defendant was irregular in payment of the loan availed of from the plaintiff caused a legal notice dated so and so issued to the defendant. The defendant gave a reply dated so and so, making all evasive and false allegations. The office copy of the legal notice and the reply are filed and marked as documents so and so to so and so. Next para should be, as per the certified extract of the statement of account kept and maintained by the plaintiff in the regular course of business, a sum of rupees so and so is payable towards the principal, and a sum of rupees so and so is payable towards the interest and processing charges, so on and so forth, and hence the present suit. Then the certified extract of the statement of account duly certified under the section 4 of the Bankers Books Evidence Act is filed and marked as document number so. Next paragraph. Since the defendant has not kept up his personal liability to pay, the plaintiff has no other alternative than enforcing the charge in respect of the house number so and so, which provided by the plaintiff, by the defendant to the plaintiff at the time of availing the loan facilities. Then next para should be, the suit is valued for the purpose of court fee and jurisdiction at rupees so and so, whatever is the amount due, and a court fee of rupees dash is paid under section 20 read with schedule 1 article 1b and c TGCSV Act. And next para should be, the suit is within time and within the period of limitation, as it is filed within a period of 12 years as required. It is filed within a period of 3 years from the date of the primary security, and even otherwise it is filed within 12 years from the date of enforcement of the charge under Article 61 of the Limitation Act. Then next para should be, no suit is filed. Last para should be, the plaintiff therefore prays for a judgment and decree against the defendant for recovery of rupees so and so due towards the personal liability, together with interest at 24% per annum from date of suit till date of realization, and future interest at 24% per annum from on so and so. Then next one is cost of the suit, then signature verification. Then after that, whatever documents are filed, then after verification, the party signs, and list of documents, whatever is filed along with the suit, you mention it. And then beneath it, the plaintiff signs. Then if it is regarding the charge which is created, the schedule of property which is offered as security, you give the complete description of the property, and beneath it, you mention it as the schedule. The plaintiff further submits that the schedule mentioned above is true and correct, and then the plaintiff signs, and the place where it is located, so on and so forth. And then the court also, where it is filed, docket is prepared. One important thing you must remember, sir, as far as recover simple mortgage is concerned, suppose you want to go both against personally against the plaintiff as well as against the charge or the property which is offered as security, wherever the property is located, you will have to file the suit there. That is section 17 or 18 of the Civil Procedure Code says the suit for enforcement of a mortgage has to be filed where the property is located. Suppose it is not in Hyderabad, it is at Nalgonda. Then you will have to file the suit at Nalgonda, but not at Hyderabad, because territorial jurisdiction, as far as that property is concerned, where the charge has to be enforced, is at Nalgonda and not at Hyderabad. and then the plaint has to be filed in duplicate as required under Order 6 Rule 1. And next one is under Order 6 Rule 15.4, you will have to file a verification affidavit, and Order 6 I'm sorry, Order 6 Rule 14, you will have to file an affidavit saying that the facts that is giving the addresses of the plaintiff and the addresses of the defendant, and then say that the addresses mentioned above are true and correct, and then sign the affidavit. And then along with that, you also file form number 8, mentioning the description of the property over which the charge is created, and then the party signs, and then you file the list of documents, 1 2 3 4 5 6, and extra number of copies as many defendants are, and then you file it in the court. Please bear one thing in mind, that as far as simple mortgage is concerned, the primary liability is payment of the debt. There's a personal liability against the debtor, or the person who has availed the loan. And second one is in default, you can enforce the charge over the property which has been offered as security in the event of failure to pay the debt. That's why the second one is so on. So that's the reason, sir. Please remember Section 16 says the suit can be filed at any place where the parties reside and work for gain. But if it is coupled with a mortgage created or a charge created, you will have to file the suit at the place where the property is located, not at the place where both of you stay. This is a very important thing you must remember, sir. And whenever you're filing for enforcement of charge, then you will have to file it. The suit has to be filed under Order 34 Civil Procedure Code, not under Order 7 Rule 1 CPC. Then one paragraph has to be devoted for the particulars of the mortgage, particulars of the charge, name of the mortgagor, name of the mortgagee, amount sanctioned, amount due, interest charge, then less amount paid, then description of the property which has been given as security, then you give it, and the list of documents that has been deposited while creating the charge, that also you give, and the total amount due you mentioned. So this paragraph has to be mentioned without fail. If you don't do it, then please remember your suit will not be numbered, and you will be deceiving your client or duping your client, where he loses the charge over the immovable property which has been offered by the debtor to secure the loan. Then I said, what? Why do you define mortgage as part paid and part promised, sir? When you apply for a loan facility, suppose you apply for a loan facility of 50 lakhs, the bank does not give you that 50 lakhs immediately. They release it in stages. First they give you 5 lakhs, next they give you 5 lakhs, next they give you 5 lakhs, next they give you 5 lakhs, like that. So the documents are taken initially from you, and then later on they take what is called uh, various documents like COB, that is confirmation of balances every quarter, acknowledgement of debt every quarter, and they also take a revival letter saying that the documents already executed stand good, and then it is extended for a further period. That is what is called revival letter. All these three things pin up the person who is in debt and he has to pay the money. All these things have to be clearly pleaded. And please remember, as far as a mortgage suit is concerned, or an ordinary money suit is concerned by the bank, you will have to clearly mention, sir, the suit is within time and within the period of limitation, as it is in the nature of a current open and mutual account, and the last credit or the last debit was on so and so date, and the suit is filed within a period of 3 years as required. So this is as far as simple mortgage is concerned. As far as mortgage by conditional sale is concerned, you mention all the particulars, like what is called that on so and so date, the defendant approached the plaintiff's bank for obtaining a housing loan, for obtaining a loan under the so and so facility, and also executed a demand promissory note and receipt for the said sum, and also executed an agreement in proof of having availed the loan, and also executed various documents as required under the law. All the documents are filed into the court. Next para is, as per the terms and conditions of the said loan, the property mentioned in the schedule offered as security, a document in the form of mortgage by conditional sale was executed by the defendant in favor of the plaintiff, whereby the defendant agreed and undertook to pay the loan amount as per the terms and conditions and and also and also executed the mortgage deed in the form of a mortgage by conditional sale, and also stated that in case that the loan is not paid, the mortgagee or the plaintiff shall be entitled to get the property sold and recover its proceeds. And then the question, the agreement, the what is called the mortgage deed is here filed here with and marked so and so. Then, in spite of several demands, all these things are common, sir. Then here, last one is here also you mentioned the same thing, and then you mentioned the schedule also, and also verified that the schedule mentioned above is true and correct. This is as far as a mortgage by deposit. I'm sorry, mortgage by conditional sale is concerned, as referred to in section 58B of the Transfer of Property Act. Then C will the third one is whenever you file a suit for English mortgage, first and foremost is before you draft the suit, you must know the theory behind English mortgage. English mortgage is where the date is fixed for payment, and the question is the date is fixed for payment and the amount has to be paid within that particular time. And in an English mortgage, what is transferred is title is transferred by the mortgagor to the mortgagee on the condition that if the debt is paid within that stipulated date, the mortgage where the sale shall become void, and in the event of his failure to pay the debt, the sale shall become absolute, and the mortgagee is entitled to proceed through legal process and get that property sold and recover his money. That is the essence of an English mortgage. So when you write the paragraphs, the same paragraphs you write, but on what date it has been executed, what are the documents taken, and what is the essence of how the title has been transferred. Then the question is, what is the document through which you have acquired title? That is, I'm talking from mortgage's point of view. And what are the terms of repayment? Within what date it has to be repaid? Why it was not repaid? Then you address the legal notice calling upon the defendant to pay the suit amount, but the defendant received the notice and sent a reply making all false allegations, and hence the suit. Then you say cause of action accrued on so and so date when the mortgage documents were executed, and also on so and so date when the promissory note and receipt was executed, and also on so and so date when the plaintiff through his lawyer's notice called upon the defendant to pay the suit amount and the defendant did not do so. The next paragraph will be the suit is valued for the purpose of court fee and jurisdiction at whatever amount is used on the date of suit. Under section 20, read with schedule 1, article 1B and C, TSCV Act. And next one is limitation paragraph. Then you say the no suit has been filed. Then jurisdiction part of it, because the property is located at a particular place, you say that court has got jurisdiction. Then the prayer clause, what you say is that if a plaintiff therefore pays for a judgment and decree against the defendant for enforcement of the mortgage, English mortgage by selling the property bearing house number so and so, situated at so and so, then together with cost of the suit, then the plaintiff signs, the counsel signs, verification is done, whichever place the verification is done, the place of verification will be mentioned. And then whatever documents you file along with the suit, they will be mentioned in the form of list of documents. Then the party signs. Then you give the schedule of property, which is part of the mortgage and with the boundaries. And the party also says that the facts mentioned above are true and correct. And then he signs. And then the counsel also signs. Docket is prepared, and all the other formalities, Order 6 Rule 15, 4, Order 6 Rule 14, Form number 8, regarding the valuation of the property, and BATA process for summons to the other side, and then the plaintiff has to supply extra copy of the plaint, as many defendants are, and also extra copies of the documents which is filed into the court. And these are the formalities as far as filing a suit for English mortgage is concerned. So these are the three types of mortgages which we have discussed, along with the suit for declaration of legal status of the person of the deceased, declaration of legal status as far as the property of the deceased is concerned. Then we have discussed simple mortgage, we have discussed mortgage by conditional sale, and also mortgage by that is English mortgage. Then next we go to usufructory mortgage, that is 58D. Usufructory mortgage is also called possessory mortgage. Here, title is not transferred. What is transferred is Possession of immovable property is delivered by the mortgagor to the mortgagee on the condition that the mortgagee has to adjust his debts or recover his debt from the share of rents, annuities, profits arising out of the property, and then remain in possession till such time the entire debt is repaid. Here, please bear one thing in mind, that the mortgagor cannot file a suit for redemption for the simple reason that what is transferred is only possession and not title. As far as the mortgage is concerned, mortgagee also cannot file a suit for foreclosure. Why? Because he can remain in possession like a Raja till such time the entire debt is paid. This is done, I told you also regarding the finance given to films, production of films. This is mostly resorted to by film financiers. Here, in the usufructory mortgage, you mentioned that I'm coming to the brief facts of the case. That on so and so date, the defendant approached the plaintiff to grant loan facilities under so and so, and the plaintiff obliged the defendant and granted loan facilities subject to execution of a demand promissory note and also the agreement for usufructory mortgage. Both the demand promissory note as well as the agreement are filed and marked as document number 1 and 2. Next para. That as per the terms of the mortgage executed by the defendant handed over possession of the immovable property belonging to him by way of collateral security with the direction that the plaintiff should appropriate the debt from out of the share of rent, share of crops, annuities, or profits arising out of the business. And the original mortgage deed is filed herewith and marked so and so. Next para. That as per the plaintiff is concerned, a sum of rupees so and so has been recovered by collecting the rents arising out of the property, and still a sum of rupees so and so is due and payable by the defendant towards the loan loan and which the defendant has not paid till this day. Next para, cause of action for the suit arose on, that is what is the date of the promissory note as well as the collateral security which has been offered, and also on so and so date when the plaintiff through their legal notice called upon the defendant to pay the suit amount which the defendant has not done so, and hence the suit. Next, this honorable court has jurisdiction to try this suit as a possession of the property delivered as collateral security is located within the limits of Hyderabad, and therefore this court has got jurisdiction. Then next para will be, suit is valued for the purpose of court fee and jurisdiction at rupees whatever is due, sir, and a court fee of rupees so and so is paid under section 20, read with schedule 1, article 1b and c TSCV Act. Then no suit is filed. That's one paragraph. And next one is the suit is within time and within the period of limitation. And next one is the what is called prayer. That is, the plaintiff therefore prays for a judgment and decree against the defendant for recovery of rupees so and so, together with the interest of so and so, from the date of suit till date of realization for cost of the suit. But please remember, I have never seen any mortgagee filing a suit in respect of usufructory mortgage. Why? Because the title is not with him. Title is with the mortgagor. But what he can ask is, whatever money is still due and payable, he can ask. But the question is, he can remain like a Raja. He need not re-deliver possession back to the mortgagor till such time his entire debt is paid. And even please remember the other way around also, the mortgagor also cannot file a suit for redemption for the simple reason that what is transferred is only possession, and title is not transferred. So that is the reason neither the mortgagor can file a suit for redemption nor the mortgagee can file a suit for what is called foreclosure. He can only remain in possession till such time the debt is completely paid. And in case of mortgagor who wants back possession of the property, he has to file a suit for delivery of possession within 12 years from the date of creation of the loan, and even otherwise he cannot file a suit for redemption. This is the case as far as usufructory mortgage is concerned. Then with this wind up today, and in the next class I'll be dealing with anomalous mortgage and mortgage by deposit of title deeds. Now the interaction starts, please. You are free to ask questions. Say tomorrow, I mean, my admin tells me that tomorrow we are reserving it completely for interaction, please. Whatever doubts you have got, present, past, not future, present, past, you can note it in the form of questions and get it cleared once and for all. Because tomorrow there will be no lecture on the subject, it will be only purely interaction. And from now onwards, every Sunday will be reserved only for interaction, please.
Hello, Jane.
Hello, good evening, sir.
There is no
तिवारी जी आप कल मिलेंगे.
Sir, you today you are winding class, sir?
Yes.
Yeah, purely interaction tomorrow. All the questions you can note down. You can get it clear tomorrow.
Okay, thank you. Good night, sir.
Good night. Good night.